Today, we're going to talk about the age-old topic we've gone over time and time again, but it is the oldie and the goodie, and everyone always wants to talk about settlements and money. And it's the most recurring theme, the biggest theme, the hottest theme, money, money, money. So we're going to talk about money today. And as always, post your questions. I will do everything I can to get to every question that I can today. So what's the first big mistake injured workers make when settling their workers' compensation case? And this is a biggie. I just want to switch this over here because I pushed the wrong button. There it is. So what's the first big mistake that people make when they settle their cases? One of the biggest ones that I see a lot of times is accepting that early offer. A lot of insurance companies, sometimes they know the complexity of a case or the possible overall exposure on a case. And sometimes they'll hit you with a quick, half decent number. You know, they might know that if they get wrapped up into a case, it could cost them hundreds of thousands of dollars in medical and lost time and things like that. So sometimes they'll throw a half decent number at you. Sometimes they'll throw a 50, 60, 75. The slide is too big. I think I fixed that. They'll throw a half decent offer at you to entice you to just take it and run. Take it and bill your private health insurance. Take it and let your workers' compensation case go. So oftentimes it happens before you get a lawyer involved, and I've seen it happen a lot where, you know, a case is a few months old and somebody calls me because now they start having questions or they want to know if that offer is a good one. And I'm saying, well, you know, let's think about this because it might not be. So early offers, insurance companies do that. It is a tactic, a technique they use to try to avoid liability on a claim. And it's sometimes a very big mistake. We've had clients, listen, even if you're represented and the insurance company makes an offer, I always tell my clients, if an insurance company offers to settle your case for $10, I am obligated to tell you about it. And I will certainly go through the pros and cons of that settlement with you. But I don't recommend 99.9% of the time, I do not recommend you accept that early offer. We can usually do better. Another big mistake that people make is thinking that the insurance company is on your side. Insurance companies are very good at this. Oftentimes, not only does the adjuster or the case manager or whatever terminology that you want to use to describe the person who's involved or who's managing your case, but oftentimes they also use a nurse case manager. And a nurse case manager, this is especially in bigger cases, more severe, significant injuries. But they're very good at being nice to you and making you believe and think that they are there to protect you. The insurance company is there to protect the insurance company, number one, and the employer that it represents and insures, number two. And if there's a way to give you what they think you're entitled to for less than you think you're entitled to get, they're going to do it. And, you know, we just had a case recently. We had a gentleman who had a very, very significant severe injury, and the insurance company sent the nurse case manager in before I could even really get involved. And he fell in love with her. She's the best. She's here to help. How do I not use? And I said, she doesn't work for you. She doesn't work for me. She doesn't work for us. She works for the insurance company, and she's there to make sure to keep an eye on the treatment that you're getting and to try to trim costs whenever possible. So you need to be mindful of that. And the same holds true with the case adjusters. So you got to be very, very careful. Another huge mistake that we see sometimes is not negotiating. And it baffles me how often this happens. You know, an insurance company, the dialogue when it comes to settling a case can go a lot of different ways. Sometimes we'll get an email or a call from an insurance company, or it happened in court, and they'll say, hey, is your client interested in settling the case? I'll say, well, I'll certainly reach out and talk to my clients, and I'll have a discussion with them to see if it's something that they're interested in. Do you want to make an offer? And a lot of times they say, no, give us a demand first. Well, that's usually how it goes. Usually the insurance company, I'm a big fan of never. Well, you can't say never, but I always like to get a number out of them first to see what their baseline is and vice versa. But a lot of times we do have to come up with the initial demand first. But from time to time, an insurance company will make an initial offer, and they'll say, hey, we'll give you $15,000 to close this case right now. And listen, $15,000, and I don't care who you are, $15,000 is a lot of money. $20,000 is a lot of money. You know, depending on your circumstance, Any type of thousands of dollars is a lot of money. And sometimes people say, you know what, that tickles my fancy. That's going to pay my rent. That's going to pay my outstanding credit card bills. That's going to get me back to square one. I'll take it. And you don't know how many times, and then like we'll start talking about it. Well, you understand a fee is going to come out of that. You understand you're responsible for future medical. And once you start explaining the ramifications of what's going to happen, then people start pulling back a little bit. But a lot of times people jump and they say, I'll take it. And if you don't have an attorney to have that discussion with you to make you understand what will happen, if you just take it, you're putting yourself at a disadvantage. So negotiating is very important, and that's really where we excel with determining the true value of your case. As an attorney who does this, we're able to have a better way of estimating the true value of your case, which you can't. And it's funny, not just as often as our clients or injured workers overvalue the case, which is what you would think would be more common. I want $1 million, or I want $2 million, or I want $500,000. They also undervalue their cases a lot. And it's funny how a lot of times they'll say, well, if I could just get 10 grand here, and I'll say, I could probably get you closer to 30. And we had a very similar circumstance happen just the other day. We were going back and forth, and we were in the low teens of thousands of dollars on a case. And my client was ready to just say, listen, we'll take it. And I said, relax. Here's what I think. Here's what I want to do. I want to go and hit them with a bigger number. I think I can get you in the $30,000, $35,000 range. And sure enough, after a phone call and a little back and forth with the carrier and me on the phone, that I think it was a $15,000 settlement, turned into a $35,000 settlement after a 45-minute phone call. And you know what? I did my job, and I'm happy, and I got the result that we're looking for. So that's why it's important to have a lawyer who understands the workers' compensation system, a lawyer who looks smart when he wears glasses because he's dealing with his eye injury, but is happy to be here for you. And that's me. 212-406-8989. I see the questions pouring in, and I love it. Let me just hit a couple more slides, folks, and I'm going to start jumping into some questions here. So, what mistakes do injured workers make when deciding which type of settlement to use? So, this one, we're probably going to do a full live on just the different types of settlements. I know we've done it and we touched on it before, and I believe we did do a live on the different types of settlement, but it's worth doing again because, settlement is a very generic term. I always say that people use the word disability. Oh, when am I going to get my disability benefits? Well, disability benefits it's a generic term. And sometimes people don't truly understand what the different forms of settlement are in the workers' compensation world here in New York State. I can't speak for other states and other places. I can only speak for New York State, but settlement can mean a lot of different things. And, some people think that a judge's final decision, finding a schedule loss of use or something along those lines, is the settlement. It might be the final lump sum payout of your case. It's not necessarily a settlement. So we got to understand what the different types of settlements are and how to use them and choose the one that works best for your particular circumstance, because they're not all the same and they all have different, I keep using the term ramifications, but they're applied in different circumstances. And I'm going to give you an example on the primary two. The first type of agreement that we use, and it's probably the oldest of the list, is the stipulated agreement. And a stipulated agreement is an agreement. And we have a form called a stipulation. We call it the stip. It's a form. It's a blank form. We put your case information at the top. Everyone signs at the bottom. And the middle is completely blank. And we fill in the blanks with what we want. And that could be 100 different things. We could stipulate to temporary benefits. So if we're arguing over what your level of disability was from your first IME to your second IME, a 3-month period, rather than sit here and fight about it, we can just come to an agreement. And if everybody's on board, we could put it on a stip, sign it, boom, formalize those awards, you get paid those awards, and that's it. That is a settlement of one portion of your case. So it is a settlement and your case still goes on. You can also settle permanent disability, whether it's permanent partial or the non-schedulable injuries that we discussed in the past, or schedulable injuries. Our doctor says you have a 35% permanent disability to your shoulder. Their doctor says you have a 25% permanent schedule loss of use of the shoulder. We agree to a 30%. We split it in half and give you the 30%, and boom, we could put that on a stipulation, and it'll be formalized by the court. You'll get your money. and case closed. What are the benefits of a stipulated agreement? For the most part, you can reopen that case if you have a worsening in your condition. If you have if your condition worsens, you do have the opportunity to have your doctor, with medical evidence of a worsening in your condition, reopen that case, and potentially you could pursue additional benefits if necessary down the road. Now, you contrast that with the other type of settlement, the Section 32. And I know we talk about Section 32 all the time. When people say settlement, I want to settle my case, that's what pops into my head. Section 32. Why? A Section 32 is a full and complete and 100% absolute closure of that case. You box it, you tie it with a bow, and you throw it on down the line because it's closed forever. That is the settlement that I think of when we talk settlement. The only caveat to a Section 32 settlement being a full and final total closure of that case is what's known as an indemnity-only Section 32. An indemnity-only Section 32 closes the indemnity portion of your case. And when you hear the word indemnity, think money, the money side of your case, but it leaves the medical side of your case open. So most Section 32s close out the medical and the indemnity. They close the whole case. But sometimes, in certain circumstances, it's easier, it's more appropriate to leave the medical open and close just the money side of your case. But when you do close it with an indemnity-only Section 32, that part of your case is closed forever. So if you do have a worsening in your condition, you cannot reopen that part of your case to get more money. The only time you can ever reopen a Section 32 is if all parties, including the carrier and including the compensation board, agree to do that. And in reality, neither will. The carrier paid you off to get rid of you, and the insurance company doesn't want to make bad law by reopening a case. So they're probably not going to allow it. They want to move on. So what are the benefits to doing that? Usually you get a couple more bucks because you are agreeing to close your case forever and be done with it. And the example I wanted to give you, and it's a case that popped up just, was it earlier this week or last week? We have a client who needs a total knee replacement, but he doesn't need it right now. His case is finished. He's done with his treatment. Physical therapy is done. And his doctor said, you're due for a total knee replacement. You could get away with not having one now or for the next few years. You're going to need it at some point in the future, but you just don't need it right now. And that client said, look, I want to settle my case. I want to be done with this. I don't want to keep going on and on. And what should we do here? And you know what I thought? Well, this is perfect for a stipulated agreement. Let's find out from your doctor what your level of permanent loss of use is to that knee. We'll see what the insurance company has to say. Let's work out some resolution of what your scheduled loss of use is. Let's close the case, get you some money, and let you move on with your life. And if you need a knee replacement, if your condition worsens in 3 years, well, then maybe we have to reopen the case in 3 years. And if it's 10 years, then maybe it's 10 years. You do have a limitation of 18 years, so you can't go too long, but I don't think that's going to happen here. But that's the only thing to really keep in mind. So in that circumstance, based upon that set of facts and that person's case, it makes more sense to do a stipulated agreement on schedule loss and not do a full and final Section 32. The other types of settlements that we see sometimes, you have the indemnity-only Section 32. Sometimes we do structured settlements. Usually that's when we structure the medical side of a case. So if we do a full and final Section 32 and we close the indemnity side for X amount of dollars, $100,000, but the medical side was also very valuable. Let's say that was $100,000 as well. Insurance companies might choose to structure that with an annuity. They'll purchase an annuity, which pays you over time to get you that money because you need it for treatment for the rest of your life. And sometimes we can use that to get you a little bit higher a higher settlement overall because we're saving them money by allowing that annuity to happen. So again, just examples. A lot of questions coming in. Man, you guys are the best. Let's just hit one more quick slide. What mistakes do injured workers make when calculating the value of their settlement? So a lot of mistakes, they don't understand future medical costs. When you're calculating the value of your settlement, if you're doing a full and final, we're talking Section 32 settlements now, you have to factor in the cost of your future medical care, medications, vocational rehab, Social Security is a factor, any attorney's fees that you might have to pay down the road. Cost of living increases are an important factor. So you need to have you have to be able to take a look at the big picture here. it's not just getting money and running. You need to make sure you're prepared and you're set to take a settlement and move on with your life in a positive direction. Because with a Section 32 agreement, and we have had this happen, client calls you 2-3 years later and they say, "Hey, I need more money. I spent all my Section 32 money." And it's a heartbreaker to tell them, "Sorry, you're done. You're out. You're finished. Like, nothing I can do to help you." It's sad, because then you have a person who's hurt, who doesn't have any money left, and what are you going to tell them to do? Other mistakes that people make when calculating the value of their settlement is overvaluing, and this is the biggest one. And this is why having an attorney, again, is so important. I can't begin to tell you, when people, sometimes it gets heated. These discussions get hot, and sometimes you say to somebody, "Well, what are you looking for?" And they say, "I owe 6 months worth of rent, and I owe $50,000 on my credit card, and I owe child support, and I owe this, and I owe that, and I owe this, and I owe that, and I car payments. I want $750,000." And I tell them, "You're not being realistic. I understand what you owe, and I understand that if it adds up and you add some futures onto that as well, it's a big, big number. I understand that, but there's nothing in the law that provides compensation for that. So you need to keep the valuation of your claim reasonable. Overvaluing your claim, shooting for the stars. I understand it's also a technique that you use in a negotiation. Shoot high and fall somewhere reasonable. But we use a term called non-starter. If you go and ask for $500,000 on a case that's worth $50,000, it's a non-starter. The insurance company's going to laugh at you and ask you to move on. Sometimes they try to use that to their advantage. We had a little run-in today where that happened, where I made a reasonable high demand, and I was told that they wanted a lower demand, and I told them, "I'm not doing that. I'm not negotiating against myself." So we're in a battle, which I will win. But overvaluing your case, yes, your rent, your back rent, your child support does not factor in. Your child support factors in when it's time to pay you whatever it is they're going to pay you. If you're in arrears, if you owe child support, they're going to take that out, but they're not going to use that to value your case. Undervaluing your claims, like we said before, is also a problem. Miscalculating average weekly wage, lost time, and degree of disability. The three biggest factors in determining the value of your case. A lot of you guys know that you post questions on the videos, and I try to answer as many as I can. But I feel like that answer I've given in the last 2 weeks more than any other answer. I keep repeating that. Hey, I hurt my back 3 years ago. What's my case worth? What's your average weekly wage? What's your lost time? What's your overall level of disability? Those are the three most important factors in determining case valuation. And degree of disability is what's your temporary degree of disability, what's your level of disability as you've been progressing, as you've been getting your treatment, and what's your level of permanent disability once you've been classified. Those are the big factors in determining value of a non-schedule case. Understanding the difference between a schedule and a non-schedule case, also very important. We have a lot of clients. I had a construction worker in here yesterday, the sweetest guy on earth. Him and his wife, he lost 2 fingers, partial amputation of 2 fingers in the accident. And you start hearing questions about, I'm never going to be able to do things that I used to be able to do. I'm never going to be able to work to the capacity that I worked before. As a construction worker, I'm missing half of 2 fingers. And you know what? I'm 99% sure this is not a loading circumstance. Let's change our hypothetical. Let's change it into a hypothetical. Loss of 1 finger, a loss of a pinky finger. I'm never going to be able to do what I was doing before. Loss of a pinky toe, the least valuable appendage in the schedule chart. You lose a pinky toe, you have balance problems. You have problems with your gait, walking. There's all sorts of problems that come from the loss of a little baby pinky toe. You're not going to be the same, but you're not going to get benefits for the rest of your life. You're not going to get classified with a permanent partial disability, most likely. You're going to get a schedule loss award. So understanding the difference is very, very, very important. Let's hit some questions here. I hit half the slides in 25-minute time. We do Cy does good work. Help me with these slides, and I don't want to. I want to make sure we get to the meat of our discussions. Ida, is my face getting cut off? I can't see because of that phone. Is a little bit cut off. Okay, let's see what Ida has to say. Thank you, Rex. Thank you, Ida. I won my hearing, got my average weekly wage corrected. I hope corrected in this way and not this way. And my sites of injury on the record. Now just waiting for the approval for multi-level spinal fusion. Thank you again for everything. I love hearing good news. Go get your surgery if that's what you and your doctor have decided you want to do, and you're going to do that. And it's going to make you better. I love hearing good stories. Luke. Hi, Rex. I have MMI for permanent rating, but the judge put me on the job search, and I have MMI January 10th and a hearing for the rating on February 18th. What if I can't find a job, or I find a job and can't do it? Okay, so you are Mr. Labor Market Attachment today. This question has been the subject of an entire video and an entire live stream. So you are at that point, that crucial point that happens in a lot of cases where, and I'm going to hypothesize about a lot of things with your file here, because I don't know truly what's going on, but I'm going to give you the information. And a lot of times, and it could or could not be the circumstance in your case, your doctor's been finding you totally disabled since your accident, and your case could be 1, 2, 3 years old, something like that, and your doctor's consistently found you to be totally disabled, and the insurance doctor has always found you at different levels of partial disability, whether it's a 25, a 50, or a 75%, and you've always kind of, your money has fluctuated, and you've always reached tentative rates of compensation with the insurance company. And now the judge has directed you to produce permanency reports, and your doctor provides a permanency report that says Luke Skywalker had lost his hand when Darth Vader sliced it off, and he also has neck and back complaints, and he's capable of sedentary work. So boom, the hammer just fell. Because all along your doctor's saying you have a temporary disability, a temporary total disability. But now with his permanency report, he's saying he's not changing anything, but he's saying that based upon that chart, you're capable of sedentary work, sit down work. And now all of a sudden, he's admitting that you have some. A Roomba is attacking my door. Now your doctor all of a sudden is saying you're not totally disabled, you're partially disabled because you could do sedentary work. And what does the insurance company do? They drool a little bit, they salivate, their eyes get really, really big, and they attack. And they now say, labor market attachment, you have to go look for a job. And they trigger the labor market attachment obligation. And what does that do for you? You now have to go look for a job within your restrictions. You have to perform a good faith, ongoing, persuasive, blah, 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 blah work search. You have to go look for a job within your restrictions. And you have to show the judge that either you've done everything you could to try to find a job within your restrictions, or you found a job within your restrictions, or they're just not hiring. You just can't find one. And it's such a tightrope, because factors that could work for you, they use against you, and factors they could use against you, they work for you. I mean, and I've given this example before because I've seen it happen, where I had a client who went around he wasn't computer savvy. He wasn't really able to go online on his phone. So what he would do is he would walk around his neighborhood, and any place that had a post, a job posting in the front of the store, or any place he could find where there was they were hiring, he would go to all those locations and do the best he could, fill out applications, and do everything he could to try to find a job. And when he went through every business in his local area that he could possibly find that was hiring and exhausted them all, he started going to places that weren't openly advertising that they were hiring. And they used that against him. They said, this guy's just willy-nilly walking into businesses saying, hey, are you hiring? No? Great. I'll see you later. Walking out the door and writing it on the piece of paper. And I said, Judge, he's exhausted all of his possibilities for places that were openly hiring. So he has to do that in order to keep his work search going. And we didn't win that argument. And I was pissed because this guy was really doing everything he could. So getting hit with the labor market attachment requirement is, you want to avoid it at all costs. Well, that's not true. You don't want to avoid it at all costs, but you want to avoid it in most circumstances. And when you are tagged with it, you got to do everything you can. And I know we've discussed this before, doing an independent work search, going to the various agencies out there, Vested, Access VR, Workforce One, all those things, and coming up with as much evidence as you can. Let them choke on your evidence showing how much work search you've done. If you do find a job within your restrictions, which is kind of part of your question here, Skywalker, fantastic. It's not a bad thing. Oftentimes, it will result in you getting more money. Why? Because now you're working at a job, and workers' compensation. If your lawyer can prove that you're working at reduced earnings because of your injuries, you're potentially entitled to 2/3 of the difference between your pre-accident salary and your current reduced salary. So you're going to work the job you're working, earning the salary that you're earning, and you might be entitled to 2/3 of the difference, which is going to bring you very close to what your pre-accident salary was while doing less work. And that's not a bad thing. People are afraid of it. People say, "Oh my God, what if I find a job?" You find a job. Good, good. Listen, we're here to get you as much as we can as your lawyer from the system under the law, within the confines of the law. But the law also wants you to try to go back to work. This is not a retirement system. This is the workers' compensation system, which is here to help people rehabilitate and get back to work. And if that's one way of getting you back to work sooner rather than later, I say go for it. So, Skywalker, let's find, you know what I'm looking for. Whammo. That's a fantastic question. I really do appreciate that one. And as always, folks, I got new graphics. I'm going to use them. I like to use them. If you like what you're hearing, hit the like button, subscribe to our videos. Please, I love subscribers. My mother is down in Florida telling, "Oh my God, he's got like 4,000 subscribers." So let's make my mom happy this holiday season. And as always, let's go Mets. So, great question. That one made me feel good. Slide is too big. Sai, what are you telling me here? So Skywalker's coming back to me. Once I get permanency rating and go to my hearing in front of the judge, do I still have to look for work after I get a rating? Okay, another great point. Man, I can't give you all the gold stars today. So when does that work search obligation, that requirement, attach and detach? Well, once there's a finding from your doctors that you're anything less than totally disabled, so your doctor saying that you could do sedentary work is an opinion from your doctor saying that you're no longer totally disabled, or if the judge rules that you're no longer totally disabled. So that could come at any point in time during a case when you're litigating degree of disability. So if there is that determination that you're partially disabled, work search attaches. There's some confusion as to whether it attaches automatically or has to be raised by the insurance company. I say it has to be raised because they don't always raise it. Sometimes they get a little stupid in court and they forget to raise it. And great, we walk away and say, "You never raised it." Bleh. But when does it detach? When do you no longer have to look for work? That happens not when the doctor gives you the permanency rating, but it's when you are found to be attached. So you have maintained labor market attachment, and then you were deemed permanently disabled. So you have to maintain that labor market attachment up until the point in time that the judge makes a determination that you have a permanent disability, or if the parties agree that you have a permanent disability. So if you stipulate, like we were talking about before, to a permanent partial disability, generally we'll put in the stipulation that claimant is deemed attached to the labor market, and you can let go. But that's when it sticks with you for a while. And if you're found to not have demonstrated adequate labor market attachment, if you didn't do a good enough work search, and then the judge classifies you with a permanent partial disability, your money doesn't start. Your weeks of your permanent partial disability cap, we call it, and it's called a cap. If you have a 50% disability, for instance, you get benefits for 300 weeks. That's your cap. Every week gets ticked off the clock. So you better start doing a work search, a good one, because every week that passes, one less week of compensation you're not going to get because you weren't attached. So they'll find you permanently disabled. The clock will start, and you're not going to get any money until you, "Judge, I'm so sorry. Here's my work search. I've done a great job now. I realize the error of my ways, and please give me my money." So, and that's what happens there. Skywalker, you put me on track for a couple great questions, and thank you. That was awesome. Let's see who we got also coming up here. My mouse is frozen. Kung Fu Panda. What is that a? It's hard to tell in the picture. A calzone? Is that like a spinach calzone? Man, I'm hungry. Hello, and keep up the good work. My question is, I got approved in New York for an ACDF surgery from one doctor. I want to ACDF. Yep, I thought so. Anterior cervical discectomy and fusion is an ACDF. We have so many acronyms that it just makes it silly sometimes. So I wanted to double check. You just got approved for an ACDF surgery. Sorry. Why is this doing this to me now? I have to move this. From one doctor, but I'm getting a second opinion. Will the new doctor need to apply for a new approval? They shouldn't have to if it's approved, but they oftentimes will because people are a pain in the ass. That's really the answer to that question. Once once an approval for a particular surgery is granted and another doctor comes along because you change your mind, you want to try a different doctor, if the request is identical, they shouldn't need a new authorization. The problem is your new doctor is not going to rely on the authorization given to the old doctor because they want to make sure they get paid. The operating facility makes sure they want to get paid. The post-operative therapy place, everyone wants it in their name because they want to make sure they're going to get paid. And that's the problem you run into. We see this also a lot of times with authorizations without prejudice. A lot of medical facilities, the court will say, we're going to authorize surgery. The carrier will say, we're going to authorize surgery without prejudice. And without prejudice means they can always go back and litigate the issue. And if the judge finds it wasn't related, they can say, we're not paying. A lot of doctors' offices, medical facilities, surgical centers will say, we are not going forward with an authorization without prejudice because, in our opinion, there's a good chance we're going to get stuck and not get paid. And I don't blame them as much as I get pissed at them because I want my client to get the surgery they need. Ultimately, yeah, carriers do play games and sometimes they don't get paid. So I certainly understand it. I've been injured for 2 years. Head, right neck. Usually the neck is the neck. You don't have a left and a right neck, but whatever. I'll go with it. Right jaw, left knee, developed myoclonus 6 months after head injury. No history of myoclonus. Insurance companies procrastinating. Are they procrastinating or are they being obstructive? If your doctor has determined that your condition is causally related to your underlying case and your accident, have your lawyer present that medical. And if the insurance company doesn't want to accept it, go for an IME. You got to push. You got to keep pushing these cases down the road because yes, sometimes they do drag their feet, and you don't want that to happen to you. Let's see what we got here. Mike J. Hey Rex, I had an IME exam, redundant, independent medical exam, and the doctor report. I'm not correcting. I'm just being busting chops because that's what I enjoy doing. And the doctor report stated voluntarily guarding. I think you're saying that the doctor knew that you were guarding. Guarding is when you're like, if it's an elbow case, I always think of the elbow case. Can you move your arm up and down? No. Guarding. Had a hearing, the workers' compensation judge ordered them to have a permanency report within 75 days. What happens next? Well, if the judge is directing permanency reports, the judge is directing permanency reports. Were you in New York? Well, if it's in New York, and we hear this from doctors all the time. I should print out a C4.3 and show you exactly. I'm going to do that. Folks, I'm going to do that right now. So I hope you're going to be able to see what I'm talking about here. I'm going to print it out blank. So when a judge directs an insurance company to produce, let me start over. Blah, blah, blah. When a judge directs the parties, either party or both parties, to produce medical evidence of permanency, the form that we use is called the C4.3. Okay. And let me just print out the first 2 pages of this form because those are the ones that actually, yeah, just do it that way. 1 and 2. The C4.3 is the form that we use. We're going to hear a little printer noise in the background there. I apologize, but that's it costs doing business, folks. That's the form that your doctors are supposed to use. Here's the problem I run into. When a doctor hears a C4.3 is being requested, they say, oh my God, somebody's asking us to comment on your permanent disability. Well, yeah, we are, but you can also comment that the the disability or the condition is not yet permanent. And doctors seem to miss the first part of that. Before a doctor can comment on your level of permanent disability, whether it's a permanent partial impairment to a neck or a back, whether it's a scheduled loss of use to an arm or a leg or anything like that, the doctor must first reach the determination whether or not you have reached maximum medical improvement. And that's step one. And they seem to forget that step one is necessary before they go to step two. Step one comes first. So if a judge says, please provide your opinion as to permanency on a C4.3, it doesn't mean that the judge is forcing the doctor to find that there is a permanent disability. The judge is forcing the doctor to file a C4.3 where he can comment on permanent disability and MMI first before he moves on to step two. Now, here I present you with, and let me see, there it is. I think everyone can see it now. Let me move this way. Doctor's report of MMI, permanent partial impairment. This is your famous C4.3. I feel like I am holding the Constitution. That's the form. Okay, so page one of the form, and you could get this online. You could just Google New York State Workers' Compensation. When you go to the board website, there's a section of forms. It's the C4.3. So the first page is patient's information, doctor's information, billing information, and diagnosis codes. So there's a code for every diagnosis. But when you go to page 2, section D, and I'm going to try to see if I can you see that? Page 2, section D. And at the top there, you see there's a question with 2 check boxes, yes and no. What is that question? That question is, has the patient reached maximum medical improvement? Yes or no? If yes, provide the date patient reached MMI. Okay, and they leave a line. So you put the date. If no, describe why the patient has not reached maximum medical improvement and the proposed treatment plan. Attach additional documentation if necessary. That is where your doctor can now check off no and write in that box and attach a 1,000 pages of medical documentation explaining, I believe the patient still needs surgery and post-operative care and yada, yada, yada. And he can explain all the reasons why he does not think the person is at maximum medical improvement. And that's totally okay. As long as he submits it on the stupid form, we're good. So, Mike J, just because they're asking you to produce permanency doesn't necessarily mean that you're going to be found to have a permanent disability. And this is an important distinction that you and your doctor need to discuss. Great question, Mike. And for that, my friend, we're going to go and find the gold star. All right. Got some good ones today. You guys are hard-hitting questions. Tony. I see Tony here is asking me questions about a North Carolina settlement with resignation. Tony, I don't have an answer for you, Tony. I do have a firm that we work with in North Carolina. If you want me to set you up with them to answer your questions, give me a call. But yeah, I don't know the answer to your questions. I am only licensed here in New York State. I am always more than happy to answer all your New York State questions. If you do have out-of-state questions, give me a call. We have a lot of friends in low place. We have friends across the country that do workers' comp in most states. And if you have a question, we can certainly do our best to help you out. 212-406-8989. RJ MacPot 720. How long should a case take for someone who was working as a driver and ended in a crash with 100% fault of the other driver, sustained has an injury of several hernia, okay, and torn meniscus? The length of time here in New York State, the type of accident doesn't dictate how long your case goes. Your injury dictates how long your case goes, generally speaking. We've seen relatively minor. We have a case here where a gentleman was lifting a can of tomato sauce, not just a little can, but the big can, the commercial size can in a pizzeria. I believe it was in 2017. Case is still happening. We've had cases, it doesn't get bigger than a death claim. Death claims get wrapped up relatively quickly. So it doesn't, you can't go by the nature of the accident doesn't always dictate how long a case lasts here in New York. The length of time that you need treatment and how long that case has issues, that really tells us how long a case lasts. So it sounds like it's pretty horrible. And if um, somebody else was the cause and they were not a coworker, certainly it sounds like you might have a nice third party case there. So I do hope you have an attorney that's handling the third party and the workers' compensation for you. If you have any questions as to what the ins and outs are there and you want to give me a call, 212-406-8989. Stendhal, New York, long time supporter of the channel, my friend. Good afternoon, Rex. How long does it take to schedule approval hearing of my Section 32 by the judge? Can my lawyer mention during my hearing my expenses in order to get reimbursed? Okay, great question. How long does it take? It really comes down to a first come, first serve type of thing. And the board, and I think I answered a question on somebody's post last week about this. The board has been running a little bit slow on getting Section 32 hearings scheduled. They have been modifying the system a little bit, and they're taking the lower value, I believe $10,000 and under Section 32s, and giving them desk decisions, which means a hearing is not necessary. They issue a decision that says, we reviewed it, we approve it, and I see a lot of pop-ups on IG. I'm going to get to you in 1 second. But yeah, desk decisions under 10 grand, they review it, they approve it, and they give the parties 30 days to change their mind. Is it 30 days or 10 days from the approval date? Either way. So those are happening a little quicker since they're now changing the system. And because of that, it's speeding up the overall system because they're taking those cases out of the general queue of cases that are waiting for a hearing. It is speeding up. I tell people as a general rule, 6 to 8 weeks from the date that the final submission goes to the board. That's the date that all parties, that the last person that has to sign signs, and it gets sent to the board. Not the day you sign. Sometimes it's the day you sign, but sometimes it's the day that the insurance company signs. So usually 6 to 8 weeks, but it could be longer, could be shorter. It's very hard to say. What I do for my clients when they come in, on the day that they come to my office to sign settlement documents, I look at my calendar and I look at which cases are on for settlement hearings that week. And I look back to see when they were submitted. And that gives us the best idea of how long it's taking to get a hearing. So, I try to use that as a baseline for estimate to come up with how long it's going to take for you to get your hearing. But again, every case is different, and sometimes they get longer and sometimes they get shorter. I think there's a first come, first serve component to this. So it's very hard to say. But to answer the second part of your question about your expenses, you really should have done that before, because it should either be already ruled upon or in the Section 32. Sometimes we do address it at that Section 32 hearing. It usually somebody gets pissed off when it comes to that because it means it wasn't brought up before. It's usually the insurance company and or the judge. Some judges get pissed about it because they don't want to. They're here to do a Section 32. They don't want to start talking about M&T, medical and travel expenses. Yes. Catherine's yelling at me. Thank you. So, call your lawyer now. Discuss your M&T, your medical and travel expense reimbursement now. Have him ask for it now, and hopefully you can get that addressed. And now, what I'm going to do, because Catherine yelled at me, is we're going to hit a couple more of my slides because they were so nice. And they deserve my attention, and you deserve to hear all about them. So, what do a lot? And we're going back to settlement discussions here, folks. That's what we're going over today. What do a lot of injured workers fail to understand about their workers' compensation settlement? What do a lot of injured workers fail to understand about their workers' comp settlement? They misunderstand what a settlement entails, what you can look for when you're settling a case. Sorry, Instagram has a very good look at my printer. I don't want to do that to you. So. It's like we discussed before, the people who are giving me how much they owe in rent, and the people telling me, that they owe child support, and you want to make a joke about it. The people telling me that they can't, satisfy their spouse anymore. Yeah, it happens all the time. People act out their lives to me. They don't just tell me about it. They show it to me. No, they don't show it to me, but let's move on, please. But people look for value, they look for money, they look for settlement of things that are not settlable. Pain and suffering is the biggest one. People always tell me, you don't know what I've gone through, the pain and suffering that I've gone through. I get it. I understand. I've had a workers' compensation case myself. I do understand it, but it's not compensable. You can be in the most intractable, worst pain in the world. You can have had the most horrible accident, the most horrible injury. Pain and suffering in New York State is not compensable. It's compensable in a personal injury matter, but it's not compensable here. Loss of enjoyment of life, not compensable. Punitive damages, not compensable. Punitive damages are what make, generally speaking, the third-party cases so valuable. What is a punitive damage? It's punishment. If you're driving your work truck for UPS, and that's funny. If you're driving your UPS truck and a guy is on his phone, not paying attention, runs a red light, and T-bones you, well, you're going to file a workers' compensation claim because you were working at the time, but you're also going to sue his ass. And part of that lawsuit is punitive damages. You want the court to punish him for being an idiot and causing you to have permanent injuries. Punitive damages apply in a lawsuit. They do not apply in a workers' compensation case. You're not going to get money for it. A lawsuit, the purpose of a lawsuit, the purpose of suing somebody is to try to make the victim whole with money. Now, a person gets hurt, you get into a car accident and you have a broken arm and your back is injured and you go and have back surgery. Okay, well, the surgery is going to help you get better, but you're never going to be 100%. The purpose of that lawsuit is to make you whole with money, and then a little more money for punitive damages and more money for loss of enjoyment of life and pain and suffering and blah, blah, blah. It's to make you whole with money. Workers' compensation, by definition, will not do that. Workers' compensation will not make you whole. The most you're going to get for a week of lost time is 2/3 of your salary. So by definition, you're already operating at a loss. You're working from behind. So expecting that you're going to get your full salary back and expecting that you're going to get all this money, it just doesn't happen. And you need to be conscious of that. You need to be mindful of that, because people all the time will say, I was earning $100,000 a year last year. Well, you're not going to earn it on comp, which is why, like I said before, in the work search realm, if you're able to go back at light duty, sometimes it's the best thing to do, because you're going to get some money out of it, and you're still going to get workers' compensation if your lawyer can prove your reduced earnings are work-related. So it's very important to just, you have to have reasonable expectations. One thing that people don't expect and happens all the time, when you explain it to them, they always get cheery. New York workers' compensation benefits, financial, monetary, indemnity benefits, like we said before, are tax-free. So that's kind of a perk, a bonus. We base your rate of compensation on your gross average weekly wage. We look at your gross salary, your pre-tax salary, not your take-home. We look at your gross salary, and you get up to 2/3 of your gross salary tax-free. So your gross salary, when you are earning your paycheck, is taxed to give you your net. We're going to get you up to 2/3 of your gross salary. So, and it's tax-free. So kind of, that's a little bit of a perk to kind of bring your compensation rate closer to what your earnings were. But you will not get 100% of all of your outstanding benefits. You will not, of your outstanding salary. You're not going to be made whole. Unfortunately, we do the best we can to get you as close to that point as possible. But by definition, you're operating from behind. Sometimes, in certain circumstances, also the benefits that you receive while you're out of work, while you're disabled, get deducted from your final award. Schedule loss of use cases. So if you have a 10% schedule to a shoulder, you're entitled to 31.2 weeks of compensation payable at that maximum 2/3 rate. If you were out of work for 6.2 weeks and you were paid total compensation for that 6.2 weeks of lost time, when it comes time to pay you for your schedule, they're going to take a credit for that 6.2 weeks, and you're going to get 25 weeks because you already were paid 6.2 weeks of that. So they take credit for your prior payments. So that's something to expect as well. All things, reasonable expectations are very, very important, especially when it comes time to settle your case, which is why having an attorney who can explain it to you so you understand it and you don't get blindsided by this is so important. And that's why I do just that. 212-406-8989. Moving on. What mistakes do injured workers make after receiving their workers' compensation settlements? And this is what we discussed before. Mismanaging funds. Man, you have to plan for the rest of your life. And sometimes settlements, I've had clients take their settlements, and like you want to hug the people and say, hey, do you have a financial planner that I can call? Because I got all this money now and I want to know what to do with it. I'm not just going to dump it in the bank. Yeah, man. Call somebody who knows what to do with your money and, um, prepare for the rest of your life. And you can use that money. You can use that money to make money to live off of. You can use that money for a lot of different things. By the same token, there are people that go to Bora Bora and come back to me a year later and say, hey, it's all gone, but damn, do I have a nice tan? Yeah, but now you're shit out of luck. So you need to be very mindful. We had a client years and years ago, and I mean, granted, it was a horrible injury, and the third party settled. But all I remember is him pulling up in front of the board in a pimped out Range Rover, iced out, gorgeous watch, beautiful clothes, and he came sashaying into the board for a hearing. This is back when hearings were in person, and I'm like, Jesus. And what happened? Ran out of money. And it was, it's tough to have that conversation with people. You gotta plan. Spending money the wrong way on the wrong things. Part of when you settle a case, if it's a full settlement and you do incur medical expenses in the future, you have to monitor your medical. You have to pay for any future medical care, especially if it's a formalized Medicare set aside, and your lawyer will and should talk to you about this. And if you have any questions, you can call me about it. If there's a formal Medicare set aside, you have to keep records of the money that you're spending, and you need to spend in accordance with the medical treatment guidelines. So, if you settle your case and you keep going for ongoing chiropractic treatment, and I don't know the exact number that the New York medical treatment guidelines authorize for a chiropractic visit, let's call it $50. If you go to a chiropractor who says, well, I will never take $50 for a chiropractic adjustment, I charge $150, and you go paying him out of your pocket $150. If you run out of money and you go back to Medicare and say, hey, Medicare, you told me to set aside all this money, it's gone. They're going to say, you've been paying this schmuck of a chiropractor triple what you're supposed to be paying him. We're not going to give anything. Go get your money back from him and keep going. So you need to be very mindful, spending properly, the right prices, and setting money aside according to the Medicare set aside. It's tricky, and you need to talk to your lawyer about that. What's the absolute biggest mistake injured workers make when settling their case? And honestly, and I'm not tooting my own horn here, but I'm tooting my own horn, got to get a lawyer who knows what they're doing and who can guide you properly. The insurance company is not there for you. They're there for them. And they will take advantage of you if you don't have somebody protecting you. They have teams of attorneys. They have in-house attorneys, outside counsel. They have whatever. They have a lot of what you should have an attorney helping you, because as much as they're smiling to your face, they're not there to help you. You don't know the true value of your case. Your lawyer can help you figure that out. You don't know. You don't have the experience of negotiating a settlement. Listen, maybe you negotiated the purchase of your car. This is very different. You need to know how to do it, and you need to know what you're doing, and you need to know the right time to settle the case also. It's not always, at the end when all the cards are on the table. You want to do it when there's still some value and some surprise, because that's really where you can maximize dollar value. And listen, as an attorney, as much as I love going to court, and I love battling with the insurance companies and taking testimony and taking medical testimony and showing an insurance doctor where he was wrong and where our doctor was right. I also love sitting down and just laying it out in front of me and figuring out the value of a case, and then nailing an insurance company and just saying, look, you're offering us this, but you forgot about this, and this, and boom, values start going up and up and up. That really makes me happy and feel good as an attorney. And that you should want an attorney who loves what he does and takes pride in that type of those types of results. So if you're looking for help, and as I said earlier at the start of this, we do everything we can to help people. It's difficult when you call up and you say, look, we have a 4-year-old case and I'm on my third attorney. It's hard for me from a business perspective to get involved in cases like that. I do try to help from time to time, but it's just it's a lot that I don't have control over anymore, because the case has kind of run its course. So don't take it personally. I still love you guys, but I try to help when I can, and when I do, give me a call, 212-406-8989. It's 4:30 on the dot. That's my 1 hour mark. Let me hit you with a couple more questions and see, just answer a few more, and then I'm going to let you guys go. Much love in California. Thank you. Much love in New York. All right. Let me take a look here. Paul Vasquez got hurt in 2022, was getting treatment until I was told I needed a spinal fusion, went to an IME, said I was fine. We fought it and won, and I got my surgery in August. Do you still think I have a long time left? No. I mean, August, you're 4 months in. You want to get to the point where you're relatively stable and better. 4 months post-surgical spinal surgery is pretty new still. I would wait a little while longer. Maybe at the 8-month mark, you start planting the seed with your lawyer about maybe settling the case, see what he thinks, and you could start driving towards a goal at that point in time. So you're in the home stretch. August, by next summer, you should start getting this thing wrapped up. Kevin, though, has had multiple concussions at Walmart, haven't heard shit in 13 years. When you had multiple concussions would lead me to believe you had multiple accidents, unless you fell down a flight of stairs and you just kept. Multiple concussions makes me think you have multiple accidents. Have you filed independent claims each time? Have you spoken to an attorney? I would call my lawyer and just have a sit down and go through the cases and see what you're looking at here. Trayvon, can a QME, and as we said before, QME is usually the California equivalent of an IME, but I believe they use that acronym in other states. Can a QME rule in your favor? Then the insurance company submits an inquiry and completely changes his mind on the injury not being work related. Yeah. What we see here sometimes in New York is an IME will be asked for an addendum to his report with some other information, some other document attached, and it goes, oh, this is the smoking gun that shows it's not related. It happens, and that's why you need a good lawyer to be able to cross-examine that doctor and rip him to shreds. Good question. JJ, you talked about stipulation on a case with a knee that had to be replaced. I have a bad knee, torn meniscus, that might be in the same. I would also be able to think about a stipulated settlement. Yeah, if you have a torn meniscus that you think might be turning into, if we do see a lot with knee replacements. That's probably the biggest one where this particular circumstance comes into play. The second most popular, I mean, they're not that it's popular. The second most common occurrence of where there's that idea where future medical is going to be needed way down the road is when you have a spinal cord stimulator that needs a battery change every 5 or 10 years. Yes. Catherine is making gestures. My phone is what? Oh, wonderful. Catherine gave me the finger. I'm kidding. But yes, it's in those circumstances where you have there will be the need for treatment way down the road. That's when a stipulation is best used. You could, in theory, and insurance companies sometimes make the offer. We'll throw in a battery replacement costs $15,000. The surgery is $15,000. We'll throw in $15,000 on top of the settlement so your client can pay for his battery surgery down the road. Well, guess what? In 10 years, the $15,000 battery surgery is going to cost $25,000. And God forbid you get an infection from the incision. That money is going to disappear in a heartbeat. I never recommend that happening. With a knee replacement, who knows what that number is going to be? So I think it's just a smarter move. But look, you do what you want. And there's people that say, get me the money for the surgery. I'm going to move to Tibet and I'll find a doctor in a hut who's going to do it for nothing. And I want to just do that and, go on ayahuasca and enjoy the rest of my life with my new Tibetan knees. Whatever you want. People can do what they want. I'm just here to get them what they want. So, but that's a fantastic question, JJ. I'm sorry that you're going through it. The insurance stopped my treatment, physical therapy. Are they allowed to do that? My primary said I'm still at 100% disability. So they can do that if their IME said that there's reason for it. And again, I don't know if this is a New York case or not, but presumably they have to have a reason for it. But that's why you have a lawyer and you have courts. So talk to your lawyer, get that back in front of a judge. When or if get to the point of having strength to work. What if I can find a job, but they want to pay me more than I was being awarded using gross amounts, even though after tax it's much smaller? I would need to sit down with you and really look at the numbers. If the gross amounts are more, then the net should be more. I don't know why it would be so much less, but if you're talking about a knee and a knee only, it's a schedulable site. Going back to work sooner rather than later might be to your financial advantage. Is 2 years too long for injuries for head, neck, back, right knee, right hip, left foot, left ankle? Other party in accident took 100% of the blame because of the dash cam. If so, how long? Right now, it's 100% disability. Fault doesn't matter in New York State workers' compensation, so it doesn't matter who caused the accident. It comes down to your disability and the causal relationship, if there's any underlying pre-existing conditions, things like that. Folks, with that, oh man, you guys came in with so many good questions. Lucky Trey, I see you. Mina, JJ still has some questions. Guys, I love you all. It's just getting late, and I do have 2 clients outside, and I don't want to make them wait. So give me a call, 212-406-8989. Next week, let me just check this calendar here. I don't think, no, next week is Christmas. Merry Christmas for those who are Christmas observers. I believe it's the first night of Hanukkah. I should know that as well. Merry Hanukkah to everybody. Yes, next Wednesday, a week from today, is Christmas. What is it, Kat? 7 more sleeps? So yeah, Christmas is around the corner. So I don't think we're doing, oh man, Mr. Sai, we're going to have a chit chat. Folks, we might try to do a live on a different day, only because next week is Christmas. The following Wednesday is New Year's Day. I don't want to deprive you of me for too long, but maybe we'll figure out a different day to do a live, the next live, because I know there's so many great questions here, and we'll advertise when it's going to happen if we can swing it with all the holidays coming up. But happy holidays! Thank you so much for joining. And I do want to make sure I get to the rest of these questions. If you want to call me, 212-406-8989. If you want to save it for next week, please do so, because you guys are awesome. All these questions, I was always afraid doing these lives that I was going to get, crazy questions and people, I didn't know what to expect, to be honest. I thought it was going to be more of my friends making fun of me, because that's what we do to each other. But you guys have really made me feel good. Here's my my New Year's little speech. I'm happy that we're doing this. I feel good that I'm helping people. It really makes me feel good to know that I'm helping people who need help, who are going through a tough time. That's why I do what I do. That's why I love what I do. And the questions that you guys give me and that you challenge me with, it's awesome. If I had good eyes, I'd cry right now. But let's tune in for the next one. And again, we'll advertise it. Sai and I are going to come together and figure out a date to do the next live. And please keep coming with the good questions. Until then, happy holidays. Happy New Year. If I don't see you before then, we're going to try to see you. Happy holidays. Happy New Year. Stay safe. Stay warm. And enjoy yourselves, folks. Thanks so much. Have a good night.